off? We talked about we were talking about the clerks, right? And they create this list. Did we talk about who the Solicitor General was?
No, that's what we're on.
Okay, good. Okay, so we got the discuss list, right? And so the clerks, okay, that's what it was. So the clerks are gonna they're gonna submit the cases that should be discussed. There is also a person within the Justice Branch, Department of Justice, and their name is Solicitor General. That's their title. The nickname for that position, I've always heard it called the 10th Justice. Your current textbook calls it I can't say this, the 9th and a half. Is that how you would say that? 9 and a half, whatever. The 9 and a half Justice. So I like to say 10th Justice better because I think that sounds better. But anyway, it's this idea that this person is in the executive branch and they're helping to administer justice policy, but they are the most direct link that the president has to the court. If they ask the court to consider a case, they automatically put it on the discuss list. That doesn't mean they're going to grant cert, but it means that they're automatically going to put it on the list of things they might consider. This person, like the Solicitor General, will file a amicus brief on like every case they're going to hear, because the Solicitor General wants to tell them this is the executive branch philosophy. This is what the president wants. So it is a pretty significant influence that the solicitor will have and ultimately the president over the Supreme Court. Does that make sense? How would you say that? The 9 and a half.
I think 9 and a half. 9 and a half.
But you put the after the half or after the 9?
9th and a half.
9th and a half? That sounds so bizarre. Will you ask your English teacher how they would say that for me, please? I have to email Coach Payne and ask him. Coach Chamberlain? Okay. All right. I don't know him, her. He's great. Well, I like him.
I call him CC. He calls himself Two Chains. It's like really weird, but he's really funny.
Is he young?
Yeah, he's like 20.
Oh, is he?
He came here last year.
Yeah, I don't know. Those days are kind of past me.
He's so nice. He just has a passion.
Oh, is it that real tall, skinny one?
Yeah.
Got it. Okay. You said the beard.
Yeah, that's him.
You got a crush on him while we did it last week?
No.
That's what I'm hearing. Okay. So, anyway. Okay, last thing. If someone is facing the death penalty, we automatically put that case on the discuss list because they feel like it warrants that. Again, it doesn't mean that they're going to hear it, but it means they're automatically going to generate that list. So then what happens is we have those certiorari conferences. What I think is really cool is there is no record. We don't record it. We don't hear it. Nobody but the justices are there. The clerks aren't allowed to be there. There's no secretary. It's the justices sit around the table and they talk. And I've read different novels like of justices that have like left the court or their accounts. And it's interesting to see that opportunity. I think the idea is that they need to be able to sit in a room and hash out their ideas. They need to be able to contradict themselves, to say this, to say what about that, and to really think through. If we recorded that, they wouldn't be able to be as uncensored. And so it's just an opportunity for them to do that. If 4 justices say they want to hear the case, we hear the case. We don't require a majority. We wanted to make sure it wasn't that. We want just this idea that if at least 4 people in that room want to grant cert, we are going to hear the case. There is not a set number. The smallest number of cases I've ever seen them hear is 65, and I think one year I saw like 110. So there's not a single, it's usually somewhere around there. The last couple of years, the Roberts Court has heard less cases, but I mean it's not a set number, but it's always kind of hovered in that range. I would say like 85 is like a good way to say it. Okay. So what will cause them to grant cert? On the left-hand side, I've got a list of some things that are likely to cause them to grant cert. The things on the right are probably why they would not. There's not a rule book. I mean, there's not like a place that you can look and go, oh, these are the criterion. This is more people that have analyzed and studied the court, and they look back and they're like, oh, this is a tendency. This is something that we see, and this is kind of what seems to be causing them. Lexi.
Can we write that in this box right here?
You can. You're going to watch a video, too, about that, but yeah. But you can write it wherever you want. It's yours. Okay, so let's look on the left to make sure. As you guys read over that list, do those make sense? Circuit conflicts, we saw that, right? That was the maps where we said, like, the 5th Circuit and the 10th Circuit, they're doing something different if it's fundamental. Multiple amicus briefs. Remind me what an amicus brief is.
Oh, right there.
Amicus curiae.
Something with a court.
Yeah. Good job.
I've definitely heard this.
Friend of the court.
Friend
Yeah,
of-
I
yes,
know. I'm
okay.
just teasing you.
That's how I like.
Good. Friend of the court. Who files amicus briefs typically? Interest groups, and then also like the Solicitor General. Okay? So typically it's interest groups. If there are a lot of amicus briefs are not written just to affect the decision, they're also written to affect the court granting cert. So to say, we want you to hear this case. So if there's a ton of amicus briefs, what that says to the court is, wow, this is something that's really like percolate, like this is something that the country needs us to make a decision about. If it affects a whole lot of people, or if it's something that's just really special that the court has to decide. The best example I can think about that is the Bush versus Gore case with the 2000 election. They couldn't have said, sorry, we're not going to hear that case. Like, we needed a president, we needed solution, and we needed a decision, so we needed somebody to go, okay, we're going to make a decision in that case. They couldn't have denied that. Do those on the right-hand side, do those make sense? What do you think I mean when I say a better case in the pipeline?
Like, if there's something better than that, like, on the list.
And remember what I said, how they oversee the circuits? So they kind of know what's coming. About 2 years ago, there was a case involving same-sex marriage, which we're going to look at like towards the end of the unit. That wasn't the first case, but I think the court was kind of waiting for the right time, and they were waiting for the right kind of case. Sometimes cases are really complicated, and they just have a lot of issues going on, so they want to find the one that will be most clear, that will allow people to understand what it is they're trying to say. It has to have some kind of national relevance. This is kind of tricky. They can absolutely hear a case that comes out of Texas that affects Texas law, but they're not going to hear something that only would affect Texas. So they have jurisdiction over state law because they're the final word on the Constitution, but they're not going to rule on things that don't have some kind of national application. Then when we say they don't engage in hypotheticals or moot points, they would not rule on slavery because we've already done that. Like, we've got that sorted out. They don't answer what-if questions. I always have students that, I don't know how to get past this, who will tell me that the Congress will pass a law, and then the president will approve it, and then the courts will tell us whether or not it's constitutional. That would be them engaging in hypotheticals. They don't do that. They only tell us if something's constitutional or not if they've agreed to hear a case because we've had a conflict and it's been put into place. They don't pre-tell you something. You only know it like after the fact. Okay, this word right here is not my favorite word to say. We're going to say it together. Ready? Well, I'll say it and then you say it. Okay. Justiciable. I know, it's a hard one. So it's like justice able. That means it's a court issue. That means it's not a political question, but it involves issues of law and constitutionality. So I guess like a place where I could think where that would apply when we looked at redistricting under the Congress unit, that Baker versus Carr case established that redistricting is not political, it's justiciable. So that means that the court has a right to intervene and answer that question. Okay? All right, here's what we're going to do. We have 4 cases. We're going to have 4 applications for cert. I'm going to put it on the screen. I'll read it to you guys. Then you're going to spend some time talking about it. And then y'all have to decide, should we grant cert, yes or no, and why. So you got to think about the reasons. You're not deciding the case. You're deciding whether or not the court should hear it. Okay? Okay, we'll read a little quote first. Doesn't she just look so cute sitting there? God, I love her. She's like so much fire in this little body. She's just amazing to me. Anyway, okay, here we go. Here, I'm going to stop this real quick, and then you guys can